Thanks, Keith. Well, now for something completely and utterly different. From the excitement of opening those advent calendars this morning to the consequences of divorce and separation. Happy Christmas. I'll try not to depress you all in the next 8 to 10 minutes or so, but this talk is timely as it actually comes, believe it or not, during Good Divorce Week. Can you have a good divorce? Well, you can certainly have a bad one. How do you avoid that, and how do you protect your wealth as a consequence? Well, as with everything in life, the answer is simple: be proactive rather than reactive. Much of my life in court is spent dealing with the fallout from people who are reactive to a situation, trying to change things as a result of the breakdown of a relationship, be that transferring property to other parties, offshore, changing the structures of companies, all as a consequence and a reaction to the breakdown of a relationship. Don't do that. Every trick in the book has been tried. What is the answer? Simple: be proactive. And I will give you some tools and advice as to how to do that. So, basic question first and foremost: is your wealth protected? Well, if you don't have a prenuptial agreement, don't have a postnuptial agreement, don't have a cohabitation agreement, the answer is on the next slide. It's not. As simple as that. Good news is that the position in relation to cohabitees, so those that aren't married or in a civil partnership, it's easier to protect or restrict claims upon separation. You don't have, by virtue of being a cohabitee, unlike being a husband or wife or a civil partner, automatic rights by virtue of being a cohabitee. So commonly I will encounter people who would say, well, I'm a common law spouse, I've been in a relationship for 5-10 years. You don't have any rights whatsoever. There's no such thing as a common law spouse. The claims from a former cohabitee would arise in relation to any financial contributions they've made to property or business aligned with any promises or assurances that have been given. Difficult for those claims to be pursued. The onus is on the person making them. Of course, if the cohabitee is a partner in the business or an employee, be very careful. Don't treat them any differently just by virtue of the fact they're a former cohabitee. Big slide here. What happens on divorce? Bad news. Big slide with the leading judgment from the Supreme Court in Miller and McFarlane. That case drew distinctions between matrimonial property, to which the presumption of sharing 50-50 applies, bad news, and non-matrimonial property, to which that presumption can be more easily displaced. The rub here is the quote in the first bold paragraph relating to the matrimonial home. The party's matrimonial home, even if this was brought into the marriage at the outset by one of the parties, usually has a central place in any marriage. Note later on, however long or short the marriage may have been. Absolutely crucial. If you're going to get married and the family home or the matrimonial home will be a property that you've owned for years prior to marriage, you will end up sharing that unless you take some steps and precautions. It will be a matrimonial asset. Non-matrimonial asset, the business that you held years prior to meeting your husband or wife or civil partner, that may be a non-matrimonial asset, but be very careful about matrimonializing that and turning it from a non-matrimonial asset to a matrimonial asset. The good news, we all need some good news. How do you protect your wealth or business? Well, listen to James McFarlane's presentation, get your documentation in order, have a shareholders agreement, preemption rights, so on and so forth. 2, beware of tax mitigation implications. Accountants will advise you about the way in which to draw your income from a business, to make partner husband, wife, shareholder in the business, for them to declare dividends, so on and so forth. Great for tax mitigation, nightmare for divorce mitigation. So just be aware of that. But most importantly, for you in taking those proactive steps, agreements. So if you're going through a divorce, is an agreement going to have any impact on your divorce? The answer's on the next slide. Yes, it is. Extract from a leading case of the Supreme Court, providing you freely entered into it, both of you, full appreciation of what it says, there's been disclosure, and it's fair, the court is highly likely to hold parties to that agreement. So absolutely crucial to protect the family home, protect the business. Prenuptial agreements are crucial. This is a key area. Would your business be relevant in the event of a divorce or separation? Yes. Capital value of it, the income stream from which you generate from it, will be relevant to some extent during a divorce. Next slide. When would the business be valued? Would the business be relevant? Yes to both questions. When would it be valued? The date of the settlement discussions, if you're in court, the date of the trial. What if you own that business before you commenced a relationship or before you got married? Well, the answer then is the court would look at potentially the value prior to marriage and then the value at the point of separation. That in itself is a whole topic as to how you approach those valuations. So coming to the end of my time, trying to trot through this, the key points really to take away from this is have an agreement in place. Be proactive, don't be reactive. If you're trying to be reactive, that's when the problems are going to start.